Hello once again, Disability Law Show. Thanks for joining us on this edition, along with Sivan Tumarkin right here beside me. Going to give you all the goods on the show today. Coming up a little later on in the show, we're going to get to the top 3 reasons why you should not fear your disability adjuster, long-term disability adjuster. That is on the way, but first, a lot of stuff to get through before that, Sivan. Right off the hop, I will give you contact information. 1-855-821-5900 is the number. help@disabilityrights.ca. That's the email, and then the website is also disabilityrights.ca. We always start off, Sivan, with the week that was, something that's been happening in your side of the world as far as disability is concerned. What do you got going on this week?
Absolutely, John. It's been a very, very busy week. As has been really the last year with COVID all around us. But let me start off by telling you about an interesting phone call that I had with a gentleman in BC, just outside of Vancouver. He called me because he was recently denied his long-term disability application. And what happened there was that his younger brother had died in an accident a while back, and this gentleman was experiencing severe depression as a result. They were very, very close. It was a very close-knit family. And he's worked as a mechanic, this gentleman who called me, for over 20 years. And he supports his family. He has 3 small children. And he applied for short-term disability through work. The employer is the one paying, and he got approved, no problem. And then when he applied for long-term disability, the insurance company sent back a letter saying, we're denying your claim on the basis of insufficient medical documentation, and they also said that there's no objective evidence that he was suffering an impairment or a disability that prevents him from working. Now remember, this gentleman is experiencing psychological issues now as a result of this family tragedy. He has a family doctor that's been very supportive, that he's been seeing for over 10 years. He also has a psychologist that he sees about once a month or so for treatments. It's very expensive, obviously. He's paying out of pocket for it. And, you know, that hasn't helped yet. He's on some medications as well. And I told him, I said, send me the medical reports that you gave the insurance company. And so he sent me the letter that his family doctor gave him and the letter that his psychologist gave him. And, you know, the psychologist letter is about 3 pages long. And it's very detailed, and it talks in detail, you know, in terms of what this person is experiencing and the fact that he has worked as a mechanic for over 20 years. So this is not somebody who's just going from job to job. It's not somebody who's trying to game the system. You know, it's somebody who is a hard worker, a family man that has experienced something very tragic and has applied for long-term disability because that's what LTD is. LTD, long-term disability, is there as a safety net. And so when he got denied, you know, his first instinct was, well, I'm going to have to appeal that decision or just give up altogether. Luckily, his wife had watched our program, John, and she convinced him to get in touch with me. And so I had that hour-long chat with him. And I can tell you, John, after seeing what the psychologist wrote, what the family doctor wrote, after reviewing his policy, there is not a question in my mind that this gentleman is owed long-term disability. And the insurance company here, which is one of the big insurers, by the way, in the country, we deal with all of them. All these insurance companies, we deal with all of them. They all know us. There's no question that he's entitled to these benefits, and there's no question that we can get them for him. And you know, just to go back for a second, just speaking about the denial itself, remember, I started off by saying that he was denied on 2 grounds. One is insufficient documentation proving his disability, and the other one that there's no objective evidence for his disability, his impairments. Those are the 2, I would say, almost, you know, most common denials I see. So first of all, when the insurance company says to you, there's insufficient medical documentation, let me break that down very quickly. If you have a doctor or a therapist, someone who has examined you, who's treating you, who is putting down on paper that they have been trying to help you, you've been following treatments, and despite that, you're impaired, you're unable to perform the essential tasks of your occupation, you have sufficient documentation. Okay? You don't need, you know, 10 specialists to say the exact same thing. It's unnecessary. So when the insurance company says that to you, think twice as to whether or not you want to walk away from money that's owed to you, okay, under the policy. Because when they say that to you and your doctors are backing you up, you have that documentation, you have that support. That's number 1. Number 2, when the insurance company says to you that there's no objective evidence, again, I have yet to see an LTD policy that stipulates that you need to have some objective medical findings. Now, I'm not saying they don't exist. What I'm saying is that when you're dealing with the psychological illnesses, psychological conditions, and even physical ones, you know, when you have a backache, for example, you've injured your back, you're not always going to see that on an X-ray. or an MRI or a CAT scan, right? You can have a headache, and it doesn't mean you're going to see anything if you do an MRI of your head. So when we're dealing with psychological illnesses specifically, how are you going to have objective medical documentation supporting depression, right? That gets diagnosed by whoever's treating you, psychotherapist, psychologist, psychiatrist. So my point is that denial was nonsense. We'll be able to help this gentleman, just like we've been able to help many other people in this same situation. When people are denied, John, LTD, they should immediately reach out to experts in the field, lawyers who specialize, who focus on long-term disability. This is what we do. We do this across Ontario, we do this in British Columbia, and now we do this in Alberta. And we've been helping a ton of people, and we keep doing so. And again, it's not hard. It's not hard. You just have to take that first step and just reach out to us. And we'll chat with you. It costs nothing to talk to us.
Isn't it also the fact that just to right off the hop to be approved for the LTD, which you're owed, by the way, is it not based on the symptom, not the prognosis? I mean, that's how it's based. It might not show up on an X-ray, right?
Yeah, no, you're right. Yeah, diagnosis, you mean? Yeah, absolutely. We've seen many denials where insurance companies say, you got to have a label on your disability.
Right.
We got to know what it is. We got 3 specialists, all of them saying it's different things. Look, it doesn't matter what the diagnosis is. Medicine is limited. We know that we don't know everything. Look at coronavirus. No one knew a year and a half ago what this virus was, right? It took time for medicine to catch up, for doctors to understand what we're dealing with here. It's the same thing with many illnesses, especially complex illnesses. And sometimes it takes time to diagnose. If you don't have a diagnosis, if the doctors don't know exactly what is impairing you, right? Maybe you have a cognitive issue, you're having memory issues, you're having focus issues, things like that. Maybe it's a physical impairment that you're having. You've developed some neurological condition that the doctors don't understand exactly. It doesn't mean that you don't qualify for LTD. As long as you're unable to perform the essential tasks of your own occupation because of the symptoms, because the symptoms are impairing you, well, guess what? You should get LTD. The insurance company cannot withhold this money by saying, we don't have a label yet for your condition. So you're right, John, but we do still see this time and time again.
There's an excellent website called pocketemploymentlawyer.ca. Now, as the title would specify, our good pal and your partner, Lior Samfiru, who co-hosts the Employment Law Show, we use it all the time. But there's also a section within that website about disability law, because as you say, they dovetail nicely to each other. There's a lot of crossover between disability and employment law. So give me a little more detail about it.
Well, the Pocket Employment Lawyer was created a few years back really as a free online website, online tool that gives people the ability to get quick answers to their employment law issues, but also for disabilities. Because you're right, John, our firm in all 3 provinces deals specifically with 2 areas of law and 2 areas of law only: long-term disability or insurance claims and employment law. And we find that many people who have employment issues also have disability questions, and vice versa. People who are having issues with their long-term disability insurer are also concerned about being let go from their jobs, or maybe they have been let go from their jobs. And so they need questions. And sometimes they don't want to reach out, not just to us, but to anyone. They don't want to, call up a lawyer. They don't want to email a lawyer. They just want to get quick answers, and so they go on Google. I always say, you go to Dr. Google, and, you're going to get a whole bunch of different information, and lots of it is not accurate. And so what we did is we created this website, Pocket Employment Lawyer website, that contains information. It allows you to get information about your specific situation, not only on the employment side, but on the disability side. And you know what? When you get that information within a few seconds of using it, if you want to reach out to us because you want an actual consultation with one of our lawyers, by all means, you can actually click the button on the website and they'll connect you to us. If you don't want to do that, that's fine. You close the browser. We don't even know that you were there. But at least this website provides you with accurate information and answers, tailored answers to your specific questions with respect to your employment issues and or long-term disability questions.
PocketEmploymentLawyer.ca, that is the name of that website. Email, as I mentioned off the top of the show, it is help@disabilityrights.ca. Sivan, we'll get to our first email for the show today. Comes from Nina. Nina writes in, says, my mother has worked as a secretary at an accounting firm for the past 25 years. Last year, she broke her hip and 3 ribs in a slip and fall on ice outside her friend's condo building. She's been off work and on LTD for the past 7 months. Recently, her insurer asked her to be seen by one of their doctors, and she wants to know if she has to go.
Well, Nina, first of all, thanks for reaching out on behalf of your mother.
Yep.
Really important question. So number one, if you are asked by your long-term disability insurance company to go see one of their doctors, whether it's a virtual appointment or an in-person appointment, and we can talk about that separately, John, you do have to undergo an assessment, okay? You don't have to go to one of their doctors for treatments, but you do have to undergo these assessments. Now, they can't just keep sending you, to 5, 6, 8 different doctors. They can't do that. But if you're dealing with an injury like this, Nina, where your mother broke her hip and the ribs and all that, and the insurance company wants to figure out whether or not, her doctors are correct in saying that she should be on LTD and can't work, she has to go to that assessment. So that's the question for that. But then the second question, John, that arises from that is, okay, what should I know about these assessments? Well, you should know several things. Number one, these doctors that are hired by insurance companies, they may be the best doctors in the world, but they're being paid by the insurance company to do this assessment. And the fact that they're getting paid by the insurance company, I can almost guarantee you that this is not a one-off, right? They sometimes make a pretty good living off of these assessments. So that then means that the insurance company wants to send these doctors claimants for assessments, which means that they're hoping that these doctors that they're sending people to are going to provide reports which are favorable to the insurance company, not to the individual necessarily. And so what happens is when you are told go to one of these assessments, yes, you have to go, but you have to be prepared that the opinion of the assessor will contradict what your doctors are saying. So then, John, the question is, well, what do you do about that? Well, I'll tell you. First of all, you be truthful when you go to one of these assessments. You tell the truth. Secondly, you ask your adjuster for a copy of the report that's generated by the assessor that saw you. I can almost guarantee you that when you go through that report, you're going to find many factual errors. You're going to find many discrepancies between what you remember happened at the assessment and what the doctor put down. Note those down. Send those by email to your adjuster. Make sure that it's on the record that you disagree with some of the inaccuracies and some of the narratives in the report. And the third thing is, give that report. If it's unfavorable to you, give that to your own doctors to comment on. Get your doctors to provide a rebuttal or to provide some answers or counter positions if, in fact, your doctors disagree with the conclusions of those assessors. So that's really important. Now, John, one last thing I want to say about this email from Nina. Her mother slipped and fell outside her friend's condo. She started off with that. Well, we deal with long-term disability claims, but we also deal with these kinds of slip and falls. And it's absolutely vital that people contact us as soon as something like this happens, because there are time limitations, not only for starting legal claims for compensation for these injuries, but also for giving notice to whoever owns the area, whether it's the condo building, a third-party contractor that was supposed to maintain the place and didn't. If it's a city sidewalk, again, you got 10 days to provide that notice. So it's really, really important that if you know someone who's been injured in a slip and fall because of ice or something else and suffered these kinds of injuries, that you get them to get in touch with us ASAP so we can tell them what they need to do to preserve their legal rights. Okay, very important.
All right, pal, we'll take a short break. Get to more. As mentioned, we're going to get to the top 3 reasons you should not fear your LTD adjuster. That is on the way. In the meantime, the number that Sivan just mentioned, 1-855-821-5900 and disabilityrights.ca. We'll continue. This is the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. John Scholes, Sivan Tumarkin right there. You want to reach out to 1-855-821-5900 anytime. You can do that to ask your own questions. And mydisabilityquestions.com. That is a free website of questions and answers. You can ask it. You can actually search it. It's got a searchable database, so maybe your question has been asked and answered in depth previous to you asking it. Check it out. If it's not there, leave it there. Sivan and a member of his team will answer it for you. But as mentioned, Sivan, top 3 reasons you should not fear your LTD adjuster. Number 1 is this: your adjuster is an employee of your LTD insurer and must uphold the insurer's good faith obligations toward you as an insured. Break that down for me.
You know what? This is really key. People need to understand that they have a lot more power than they think. And John, I don't know that I've had one conversation with a claimant that's been cut off or denied LTD where I don't stress that, because people feel helpless. That's the thing. They feel like these adjusters have all the power in the world. And I understand why they're feeling that. And I'm here to tell you, forget about it, okay? It's a myth. It's an absolute myth that these adjusters have all this power. They cannot do whatever they want. They are employees. Now, they represent the insurance company, but they're not the insurance company, okay? These individuals are bound by the obligations that the insurance company has towards you. The reason they're speaking with you in the first place is because they have to, because they are doing their job. And their job is to adjudicate your claim, to adjust your claim. And you know, one of the things that people don't necessarily understand or don't think about is that when they make an insurance claim, when you're making an insurance claim, and that can be in the context of LTD or a house insurance claim or a car insurance claim, the insurance company is not there to do you any favors. You've paid for this. In the context of LTD, maybe your employer paid for this. Doesn't matter. The insurance company got paid to give you this coverage. It's a product that was purchased from them. And now when they're called upon to provide this product, they have certain rules and obligation they have to abide by, okay? And what they have to abide by is good faith. And we have this from judges from across the country, where these kinds of cases, when you know, insurance companies have not done what they're supposed to and acted in a bad way against individuals, we've had judges, I'm not going to say discipline insurers, but certainly, you know, bring the hammer down on them and you know, say in judgments that insurance companies have duties of good faith, a duty of good faith towards an individual, a claimant, an insured under the policy. So when you're dealing with your adjuster, understand this. This adjuster cannot do whatever they want. They're not allowed to abuse you. They're not allowed to bully you. They're not allowed to do anything that is disrespectful towards you. And I know that many people out there, John, feel that they are being bullied and disrespected, you know, and oftentimes are just dealt with in a very bad way. And that should not be allowed. Do not let an insurance adjuster bully you. And if that happens, by the way, reach out to me and we can have a conversation about your specific situation. But the reality is, these adjusters, they have supervisors they have to answer to. And if you complain about an adjuster's conduct, well, guess what? That supervisor is going to speak with that adjuster, maybe even switch adjusters for your claim. And if they don't, if they make your life hell, well, as far as I'm concerned, that is a breach of the policy. That means that you have potentially a legal right, a legal claim against the insurance company for how they're treating you, and we can enforce that.
Second reason why you should not fear your LTD adjuster is this, Sivan. Your adjuster cannot force you to do things that will put your health in jeopardy, like telling you to go back to work when you're not ready, or make you undergo treatments that are counter to what your own treating practitioner, your own doctor say you should be doing, right? You
know, I was just on my way here this morning to the studio, and I had an email sent to me from a lady in Alberta, just outside of Calgary. And that was her question, really. She said, look, she says, I'm not ready to go back to work. The insurance company is forcing me to try this return to work program. I've had a chat with both of my doctors, a family doctor and a chronic pain specialist. Both of them thinks it's premature. Do I have to do what the adjuster's saying? Right. And I said, no, you absolutely don't. You have no obligation to do anything that is contrary to medical advice. And think about that. That makes sense not only from a medical standpoint, because medically it would be bad for you to do something against medical advice, right? To go back to work before you're ready. It could aggravate your condition. But number two, from a legal standpoint, there is zero authority in any LTD policy that gives the insurance company or the adjuster the right to force you to do something that hurts you. The whole idea of LTD is to be a safety net, to allow you to recuperate, to get this income replacement amount of money while you are getting better. Or if your condition is permanent, well, then it's there to compensate you, to provide you with this replacement income until the end of the policy period, which oftentimes is 65 years of age. But the point is that the insurance company has no ability to force you to do something that goes against your doctor's advice. And if they do that, that's when you reach out to me, because I can tell you they're not allowed to do that, and there are ways to push back.
Okay, reason number 3 why you should not fear your LTD adjuster is this: any mistakes your adjuster makes on your file will give you more ammunition against the insurer if you are denied or cut off your LTD benefits.
And you know, they make so many mistakes. These adjusters are human beings, just like anyone else. And many of them, by the way, John, are handling over 100 files, 100 claims at any given point.
Yep.
So just imagine how many different claims they have to deal with, how many different doctors they have to deal with, how many clinical notes and records they have to review. I guarantee you that if you think something is going wrong in your claim, it's because the adjuster has missed something or is not doing something correctly. Well, guess what? When we get involved and we ask for and get a copy of the insurance company's file, they have to give it to us, by the way. When we start a legal claim, they have to give us what they have. We see the adjuster's notes. We see, the notes and records of whatever doctors are consulting. We see the guts of their insurance claim. The amount of mistakes that we see them make is astronomical. It's crazy. And that gives us the leverage then to force them to pay you what you're owed. Now, you as an individual, you can't get that. Unless you start that legal process against them, unless you know what you're doing when it comes to that, they're not going to give that to you. They're not going to have to. But when we get involved and we start that legal process because they've denied your claim or they've acted in a way that they should not have acted, well, guess what? We see that, the guts of those claims, and we use that, and we use it all the time. We've had situations, John, where we've wanted to question the insurance adjuster on the file, on the notes that they've made, and in those instances, in some of the more extreme ones, the lawyer from the insurance company called us up saying, well, how about we avoid that questioning and instead talk about how much we're going to pay your client? That's the kind of stuff I'm talking about. Because these individuals are not infallible. They're human beings. They make mistakes. They work on volume. And the reality is, again, going back to what we said at the beginning of the segment, John, people have a lot more power than they think. It's just that they need to be empowered. And this is what we do here. We give you this information. So if you're in that predicament, reach out to me. Again, it will cost nothing to speak to myself, a member of my team. That's what we do. We do these shows to give people information. If you go to mydisabilityquestions.com, that website, you'll see people have posted questions, and I've answered those questions for years for free. Okay, it's not about making a buck. It's about giving people this information. And if at the end of the day you don't want to contact me or a member of my team, then go to another lawyer, another firm. Just make sure it's somebody who knows what they're doing, somebody that the insurance companies respect. You need to get the right information. That's how you even the playing field with these, corporate entities.
All right, coming up here, pal, what to do if your insurer has cut off your benefits because they're saying, hey, you can go back to work. No. We'll talk about that. The phone number in the meantime, 1-855-821-5900 and help@disabilityrights.ca. We'll continue. Disability Law Show.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, thanks for hanging around. A few minutes to go here on the Disability Law Show, mydisabilityquestions.com. I referred to that website earlier in the show. You can go there absolutely free. Ask your questions to Sivan or a member of his team, and they will get answered quite fully. Very quickly, by the way, as well, mydisabilityquestions.com. One for today I want to get to. This one comes from Fred. Fred says, I suffered a mental breakdown due to my work environment. I was getting LTD benefits as well as CPPD, but I recently got a letter stating that I don't qualify for LTD benefits because I can do another job. I completed a work trial last month, but suffered a huge setback with my health. My doctor is changing my medication and again says I can't work. Should I try to apply for LTD again?
Well, Fred, if you were on LTD and you have had the setback after trying to go back to your job and it's been unsuccessful, then you should be able to activate your LTD again. You should be able to go back based on a common provision that we see in insurance policy called the recurrence provision. And that provision basically stipulates that if within a certain period of time, usually it's about 6 months, but you got to check your own policy. If within that period of time you've tried to go back to work and you've been unsuccessful, you should be able to go back on LTD without waiting the initial elimination period. It's that period of time when you apply for LTD, you get approved, and you don't get paid. And that can be for a few months at a time. Well, if you have tried to go back to work after being on LTD and it's been unsuccessful, you should be able to go back on LTD without waiting that period of time where you don't get paid. Now, John, here's the thing here. This gentleman is on CPP disability, okay? And CPP disability, that's government pension basically, government disability pension. That's arguably more difficult to get than LTD. Right. From a test standpoint. In other words, the qualifications for CPP disability are arguably more difficult. So if he's been accepted for CPP disability, he should be able to go back on LTD. Now, he says that the insurance company thinks he can do another job. Usually we start seeing that kind of language and discussions from insurance companies around that 2-year mark. I've seen one recently where it was a 3-year policy. So usually within 2 years, the first 2 years of being on LTD, to qualify, you have to show that you cannot do your own occupation. Okay, you can't do the essential tasks of your own occupation. Beyond the 2-year mark, or in the case I just mentioned where I saw a gentleman's policy take it to 3 years, beyond the 3-year mark in that policy, the test changes. The question then becomes, or the test, is can you do any occupation for which you're suited for by training, education, or experience? And if the answer is no, well, then you should remain on LTD. Right. But most insurance companies, or many insurance companies, end up taking the position, after having you go through some assessment, in many instances, that you can do some other work, some other job. Well, no, it's not as simple as that. First of all, the test is not can you do some other occupation, some other job. It's can you do another occupation for which you're suited for by training, education, or experience. So many people, John, end up calling me and saying, look, the insurance company gave me 10 different jobs they say I can do. I don't have any experience or education in any of these. And so the answer is, well, then you don't have to take one of those jobs. You should continue on LTD. The other way to look at it is if you can find a job, an occupation that pays you about 65% of your pre-disability income, well, then you probably don't qualify beyond that 2-year mark. But if you can't, if you can only find a job that pays you 30% or 50%, well, arguably then you should continue to get LTD beyond the 2-year mark. So my point is that don't listen to the insurance company if they're saying you don't qualify for LTD anymore because you can do some other job, if you know that you can't, especially if you know that you can't get another job or work in another occupation where you can make 65% of your pre-disability income. So Fred, we can help you with your claim. If the insurance company is giving you a hard time, and they do often, for people who actually can't go back to work, we help them. And we help people all the time in all 3 provinces, John.
Fred, thanks for reaching out again. mydisabilityquestions.com is what he used. You can go there as well, or use the phone number 1-855-821-5900. Email address we have on the show is help@disabilityrights.ca. And also to catch everything else, including our radio show, go to disabilityrights.ca, the website. And we'll catch you again. Thank you for the last 30 minutes. Disability Law Show. We'll see you next time.